All right, so after that preamble's over, all right, so we're going to move on to the Pennoyer rule, which is an adjudicated fact. It's a landmark case, 1877. It deals with jurisdiction, okay? Basically, like full faith and credit jurisdiction, like when one state has if they have jurisdiction over a person in another state, personal jurisdiction, okay? And we're not going to focus on that right now. We're going to focus on the portion of the adjudicated fact that says, well, see up here, it's a criterion for due process. So if a judgment is made in violation of due process, the judgment is void, okay? If the person issuing the judgment is without personal jurisdiction, the judgment is void. And this case is the landmark case that I often cite a adjudicated fact, Burnham versus Superior Court, that says a non-judicial person, quorum non judice, is without personal jurisdiction. Their judgments are void, and it's in violation of the 14th Amendment. So in Burnham, they cite Pennoyer versus NEFF right here. So we're going to focus on that. All right, so I'm going to jump over here. All right, the Pennoyer, it's called the Pennoyer rule, and it's the criterion utilized by courts to prove due process. Okay, this important landmark case is important to be cited in court, that under the Pennoyer rule, any judgment issued without personal jurisdiction, without due, which would be without due process, is void. Okay, so now, citing Burnham, we're going to get to Burnham later in the slides. Most of you have support orders issued by these pretenders. See, what they've done is they created a sham hearing because they know they have no jurisdiction over you. So what they do is they have a sham hearing, they have a person act like a judge, yell at you like a judge, they make you stand up, raise your right hand, they have court officers in the room, they have the whole production set up for you. And it's to give you the impression that you must follow the order or else. And these maniacs even have people arrested, which I don't know how they're allowed to do that, which they're not. Okay, now let me fall back on my my law enforcement background. I believe, based on my experience, and I would consider myself an expert at probable cause. Okay, I've testified in probably over 50 grand jury cases. I participated in well over 200 arrests. Participated, not my own, and I made over 100 arrests by myself. Many of over, I'd say about 30 to 40% of them would be felony arrests. And in New York City, felony arrests end up before a grand jury. So, and then sometimes a grand jury, the defendant, they want to go and nullify the evidence. They're gonna go after my probable cause. So then I would have to go testify in a probable cause hearing, which is much harder than a grand jury. A grand jury is a joke. Okay, there's an old saying, they can have a ham sandwich on a chair and indict the ham sandwich because the prosecution holds all the cards. Okay, so they could do anything. So anytime somebody gets indicted, it's not a big deal. Okay, but a probable cause hearing is Map Huntley hearing is it's harder because you got to expound, or you have to clarify why you did what you did. All right. So with that being said, I believe that when these people hear fake judges, the commissioners, the support magistrates, friends of the court, hold on a second here. Hold on, guys. I have this. Oh, here it is. I have the slide. I did a slide months ago of fake judges, and I just did a few of them. All right. Okay. Commissioners, right? Support magistrate, New York. All right. Friend of the court. They're all non-judicial persons. So their judgments are without any legal force because they're without personal jurisdiction under the Pennoyer rule. So that means the judgments are void. Now, when you take these judgments and then they send them out into the world, and what they do is they send them off to their, they send them to your job. They send it to the child support agency, they start sending it everywhere. And as soon as they steal $1 from you, it's my opinion now. I'm not saying this is my opinion. It's my opinion that there's grounds to file a police report. Okay? So I've thought about this often in the past. I've said in a lot of my older videos that we have to do something to these people because they all protect each other. Now, sometimes the best way to do that is to get another agency involved, and that other agency would be a police department, sheriff's department, okay? And putting them involved now, see, when you show a police officer, a deputy sheriff, a sheriff, when you show them evidence of a crime, they are supposed to act. Okay? Now, and then when you get them involved, maybe down the road, you can go after the police officer, the deputy sheriff, whatever, and threaten to sue them and force action that way. This is what I'm thinking these days. Okay? I did an older video where I put up my a copy of my retired police ID to show my credibility, and I'm showing that it's my opinion. I said it back then that I believe there's criminality here because they're stealing your money and they're using these people here as I pointed out here. When these people lack personal jurisdiction and their judgments are void, they become forgeries. Okay, they're fraudulent instruments, and when they're being used to steal your money, we have fraud. Okay, something to think about. Okay, a void judgment issued in one state is not entitled to full faith and credit in another. Okay. Article 4, Section 1 of the Constitution is the full faith and credit. And I should have did a slide on that, and I apologize about that. I just thought about it now. Okay. Judgments from one, lawful judgments and, positive law from one state is supposed to be recognized and honored in another state. So let's say you have positive law in New York. What positive law is laws that conforms with the Constitution. So, created by Congress, created by legislation, and it's in tune with the Constitution. Okay, another state is supposed to honor it. That goes for a judgment. Now, like a divorce judgment. A divorce judgment is recognized from one state to another. Okay, but if you have a void judgment is not you. Now you have to force that on your own. Okay, and the way you can do that is a writ of mandamus, a cease and desist. So what you could do is you take that void judgment, you go to a court, and you file a cease and desist against, let's say, the child support agency that's enforcing the fake judgment, your employer, who's they're enforcing a income withholding order. And the way you would win that is you present the void judgment and you argue before the court that this judgment is void because it violates the Pennoyer rule. Okay? And the Pennoyer rule says that a void judgment or a judgment issued by somebody without personal jurisdiction is void. Okay? So the way you would also do that is you show the support order, and if it's signed only by one of these people, another thing also, they're not signed by a clerk, they're signed by a deputy clerk, which is a violation of 28 U.S.C. 1691. Okay, I covered that in older videos. Okay, so that's how you would do that from one state to another. Okay, so and this is the where is the case? It's shit. This is Volkswagen. Where is it? Hold on a second. Where the hell is it? This case right here. Worldwide Volkswagen. This is a Google Scholar, by the way, guys. Excellent application. It's free from Google. Okay, and Volkswagen. This case right here. All right. Where do they cite Pennoyer? Hold on, guys. It's in the slide anyway. This is the case law, and they're citing Pennoyer. Okay, this right here. So the Due Process Clause of the 14th Amendment limits the power of a state court to render a valid personal judgment against a non-resident. Okay, I'm going to talk about that another time, another video. Again, I try and make it as simple as possible. This is, by the way, this case here, the Pennoyer, there's a video on YouTube, a couple of women lawyers, and they spent like a large portion of their semester in law school just going over this case because it's a complicated case. So what I'm doing is I'm just making it simple for all of us by saying a judgment issued by somebody without personal jurisdiction is void. That's all we care about. Okay, that's all we care. So let's make it as simple as possible. Okay, so a void judgment issued in one state is not entitled to full faith and credit in another. Okay, now you want to get a judicial notice of pointing this out, and I did a video on that. Here it is. Okay, adjudicated facts are defined by Federal Rule 201. This is just information, guys. That's all it is. All right, now I gotta do this real fast because I just listened to a recording the other day of one of my guys, and I want all of you, please pay attention. If you've not been paying attention, hopefully you are, because we're citing Federal Rule 201. What we're doing is we're forcing the court to take judicial notice of these adjudicated facts, right? Pennoyer versus NEFF. So what happens? Well, see, they pulled the trickery by going, well, federal rules don't apply in state court. I heard that on the recording, and I was waiting for my guy to yell objection. And by the way, other subscribers of mine have done this. And I had one of my guys go, yo, Rick, they pulled that bullshit on me, and I objected, and I cited Howlett versus Rose, and I shut their ass up. Just like that, he said. Because he was ready for it. So I want all of you to be ready for this. 201, get down here, right? C, subsection C, taking notice, the court may take judicial notice on its own. Let's not wait for them to do that. Okay, they're not going to take it on their own. Trust me when I tell you that. Let's go to number 2. Must take judicial notice if a party requests it and the court is supplied with the necessary information. You got it? We're going to provide. That's what I've been doing. I've been updating my paperwork, hot and heavy, pointing out adjudicated facts. So if you're lucky enough to be in a hearing and some stupid, and by the way, a lot of these attorneys are really stupid. They're not nearly as smart as they think they want us to believe. Okay? So you're smarter than them. You're going to say, Howlett versus Rose. Okay? That just as the state could be joined in an action for the violation of established state common law or statutory duties, it was also subject to suit for violation of its non-discretionary, hear this? Non-discretionary, that means the court has no discretion to not violate the Constitution. So we got non-discretionary duty not to, that means the court is not supposed to violate the Constitution. They do it all the time. That's why we have to stay on top of them. And the way you stay on top of them is know your adjudicated facts and know what they're going to do before they do it. Okay? And know the Constitution. Okay? You have no constitutional rights or rights secured by the Constitution if you don't know them. Okay? So now here we go, citing Howlett versus Rose. Federal law is enforceable in state courts not because Congress has determined that federal courts would otherwise be burdened or that state courts might provide a more convenient forum. See? Okay, although both might be true, but here we go. But because the Constitution and laws, positive laws passed pursuant to it are as much laws in the states as laws passed by state legislature. The Supremacy Clause makes those laws the supreme law of the land. Okay? That's why. So, remember, state, oh, by the way, also, let me, because I'm jumping around. Right? We're going to move on. Okay, I'm just giving information. Now, when a lawyer or judge attempts to trick you when you utilize federal laws or rules, right? State federal laws do not apply in state courts. All right. If you are in a court or the type of proceeding, you immediately call out objection. It is an adjudicated fact by the Supreme Court in matter Howlett versus Rose that federal laws apply in state courts. That's it. Don't back away. If it is written, then you file a written objection and cite Howlett versus Rose. Okay, you must be ready for these tricksters and word magicians because their job is to help the state keep the money they have stolen from you. Okay, so be prepared. So when we introduce an adjudicated fact on the Federal Rules of Evidence 201, and they give us that, then they give us the old federal laws do not count, do not apply in state courts. We're ready with the objection, Howlett versus Rose. Okay, now we're going to get to Burnham. The question presented is whether due process clause of the 14th Amendment, this is the actual first opening statement. Okay, we're going to move on from that. Okay, the proposition that a judgment of a court lacking jurisdiction is void traces back to English yearbooks. Traditionally, that proposition was embodied in the phrase coram non-judice, before a person, not a judge. Okay, who's that? Our commissioners, support magistrates. Okay, meaning in effect that the proceeding in question was not a judicial proceeding because the lawful authority was not present. okay, and could therefore yield a judgment. American courts invalidated or denied recognition to judgments that violated this common law principle long before the 14th Amendment was adopted. So this has been going on a long time, long before the 14th Amendment. But we're going to use the 14th Amendment. The 14th Amendment helps you, you use it. Don't get caught up in all this other nonsense. 14th Amendment makes you a slave and all that other bullshit. And I'm not saying that's bullshit, by the way. All I'm saying is that the law helps you, use it. Don't get caught up in all that other stuff. There's a lot of information out there to confuse you. What Rick is here to do is to simplify it for you, because that's what I did for me. Okay? And see, they cited Pennoyer versus NEFF. Okay? Because we're moving on to time here, I'm just going to leave this up for you to read. Okay? It's well-established principle of public law respecting the jurisdiction of an independent state over a person's properties. Okay? To determine whether the assertion of personal jurisdiction is consistent with due process. That's from Pennoyer, the criterion. Okay? No personal jurisdiction, no judgment. And very simply, a non-judicial person, quorum non-judice, has no jurisdiction. So all their judgments are void. 100% of them are void. Okay? The Pennoyer rule criterion, without due process, a judgment is void. Okay? I told you guys, 100% of the judgments by these non-judicial persons are void. Simple. Okay? I'll leave that up for you guys. Okay, so besides what I just pointed out to you guys, what other ways are violations of due process? Okay, proceeding without a trial by jury are in violation of due process. Void. Pennoyer rule. Proceedings in court not of record are nisi prius courts. These bullshit courts that you're in. Traffic court, like family court in New York, these domestic relation courts. What they are is if you don't object, it stands as fact. Another trick. They got some wonderful tricks, these people. It's unbelievable. Okay? So that's why, like in New York State here, they have the family court, and they have this, bullshit policy that you're not allowed to file an objection until the support magistrate issues their fraudulent order, which is, BS. Okay, but let's move on. Okay, prejudgment wage garnishments. You know what that is? A prejudgment wage garnishment is an income withholding order issued by a child support agency or Title 4D contractor, are void for violation of the 4th Amendment. Okay, what they're doing is they're seizing your property. What could seize your property lawfully or constitutionally? A 4th Amendment warrant. Okay, can only be issued on the oath, a sworn affidavit by a judge or a magistrate. Well, we know a child support agency is not a judicial body. They're in the executive body, so therefore they're violating separation of powers doctrine. They're violating the 4th Amendment. Okay, moving on. Okay, you see this here? Okay. The Pennoyer rule for victims of child support scam applies. Simply, no process, no due process, no judgment. Judgments issued by non-judicial persons, quorum non-judice, are void because non-judicial persons lack personal jurisdiction, and therefore all judgments are void. Very simple. Okay? Judgments for child support issued by judges are void. Okay, so let's say you see it's signed by a judge. Oh my God, it's signed by a judge. It's void. Why? Because it's a summary judgment issued by a judge, and they deprived you of your trial by jury. Okay, there's a quote by Thomas Jefferson that basically says that the only way to keep a government in line with the Constitution is to have a jury trial, a trial by jury. That's it. Because there's supposed to be 12 impartial people, peers. Okay. Judgments, so therefore, judgments for child support issued by judges are void because without following due process listed earlier, right? The court of record, trial by jury, okay, without a waiver of trial by jury is void. Okay, so therefore summary judgment are void. Study, and in case you've forgotten, study. Okay, that's it, guys. You have to study this stuff. Okay, you got to think the way they think. Okay, to be ready. This is a war. This is nothing but a war. All right, so we're at 32 minutes, 33 minutes. All right, so I'm going to shut this video down. Okay, I hope it helped you out. All right, real simply, the Pennoyer rule is an adjudicated fact. It's a criterion for due process. It helps us. It's a huge asset for us. Okay, if you're lucky enough to get it before and have a proceeding, let's say you're going to court tomorrow or Monday, and you're going before one of these commissioners or support magistrates, object. These proceedings are without judicial authority. They are void under the Pennoyer rule. It's an adjudicated fact, Pennoyer versus NEFF, 1877 case, that any judgment issued in violation of due process is void. Therefore, any judgment issued by you, they are void. And when used to steal my property, it's a crime. I'm telling you guys, I'm positive it's a crime. All right, I wouldn't be putting this on YouTube if I didn't believe it was a crime. Now, getting a police department to enforce it, that's a different, that's a different video. Okay, well, they're not the brightest guys going. I can tell you because I was one of them. All right, guys, listen, I'm gonna shut this down. Enjoy the rest of your Saturday.